Paths of Justice by Johannes M M Chan, Hong Kong University Press. Chapter 28. Let's kill all the lawyers. When is a pigeon not a pigeon? Every now and then, there are cases which may puzzle, if not also be amusing, to the general public, as the decisions seem to be contrary to common sense. Sometimes an awkward decision of the court is the result of poor drafting of legislation, especially when ill-considered amendments were hastily introduced, or well-intended amendments were arbitrarily rejected in the course of the legislative process. Sometimes it may just be the sheer limitation of human ability to foresee the future. The Pigeon case may be one such entertaining incident. Section 15 of the Waste Disposal Ordinance provides that no person shall keep livestock at any premises in a livestock prohibition area, which generally covers the urban area. Livestock is defined to mean pigs or poultry, and poultry is in turn defined to mean chicken, ducks, geese, pigeons, and quails. A contravention of Section 15 is a criminal offense. The Hong Kong Racing Pigeon Association, which had some 380 members, was a sporting association which raised pigeons. The pigeons were trained to fly long distances, sometimes over 1,000 kilometers, from Hong Kong to China and other countries. This sport or hobby was taken seriously by its members. The pigeons were generally kept in well-maintained lofts that were brightly lit, draft-proof, waterproof, and vermin-proof. They were expensive. A pedigree pigeon could cost up to Hong Kong dollars 20,000, and the unhatched eggs cost about $1,000 each at 1994 prices. As a result, they were kept in very good conditions. The lofts were large enough to allow a person to get in to do regular cleaning. Since quite a few birds inevitably got lost or were killed on the long-distance races, the members usually kept a substantial number, 30 to 40 of them. The problem was that when the members kept the pigeons in an urban area, they were in contravention of Section 15 of the Waste Disposal Ordinance. By an originating summons, the association sought a declaration that these racing pigeons were not pigeons within the meaning of poultry for the purpose of Section 15 of the Waste Disposal Ordinance, despite the explicit reference to pigeons in the definition of poultry. The case was argued by my former chambermate, Mr. Benjamin Chan, who had placed before the court a considerate amount of materials to substantiate the point. It was argued that, first, poultry normally means certain categories of birds which were kept either for breeding or eating. Though racing pigeons could be eaten, they were kept for the purpose of racing rather than for the purpose of food. Secondly, it was argued that racing pigeons are different from domestic pigeons. A pigeon comes from the family called Columbidae with some 306 species. There are domestic pigeons, ornamental or fancy pigeons, and homing or racing pigeons. The main difference between racing pigeons and domestic pigeons is that racing pigeons are much smaller in size, some 15 ounces compared to about 2.2 pounds in large domestic pigeons. Unlike fancy pigeons, which have fancy tails, racing pigeons are compact. Certainly, as revealed in the legislative debates, the intention of the legislature was clearly to restrict large farming operations from taking place in the urban areas to provide food for the people of Hong Kong. The legislature certainly did not have in mind or contemplate raising pigeons, which it enacted when it enacted Section 15 of the Waste Disposal Ordinance. Fourthly, in 1969, the House of Lords had decided that the word poultry in the Fertilizers and Feeding Stuffs Act 1926 meant birds that were kept for the supplying the table with meat or eggs, and was not wide enough to cover pheasants that had never been in captivity. Finally, from a public health point of view, these raising pigeons were carefully maintained and were kept at a high standard of hygiene, especially as they were so expensive. It would be odd if one could keep a large number of parrots in one's property, but could not keep a large number of raising pigeons that were normally kept in much better and more hygienic conditions. In this regard, Council also referred to the fact that the Urban Council had kept a large number of ornamental pigeons in its park within the urban area in contravention of the ordinance. Mr. Justice Sears was evidently highly amused by this learned and ingenious argument. He first described this hobby as a worthwhile pursuit that was taken seriously. As this was an important pastime, and since the ordinance provided criminal penalties for its contravention, the court should examine the matter from a liberal point of view. The difficult question for him was whether or not he could limit the meaning of pigeon as poultry to only those pigeons that were kept for food, taking into account that eating pigeon was a common occurrence in Hong Kong. He first found that the English decision of the House of Lords was not helpful, as the word poultry was, unlike the Hong Kong legislation, not defined in the English Act. So he had to turn to the meaning of poultry in the Hong Kong legislation, which expressly included pigeons. The judge then noted that the word poultry also appeared in the Public Health Animals and Birds Ordinance, which, among other things, restricts the public from importing animals and birds on the grounds of public health. Birds were defined as poultry and all other birds, and in the context, poultry was defined to include domestic fowls, turkey, ducks, pigeons, and geese. Although this was a different category of poultry, the underlying public health concern for restricting the import and movement of birds in affected areas, especially where disease was discovered, would be equally applicable and of equal cogency. While he had considerable sympathy for the association, he could not hold that raising pigeons were not pigeons for the purpose of the Waste Disposal Ordinance. He was relieved to be informed by the Department of Justice that a relaxation of the ordinance had been made to allow association members to keep up to 20 pigeons on their premises, and that the Urban Council had now been exempted from the ordinance so that it could continue to keep ornamental pigeons within the urban areas. Accordingly, Mr. Justice Sears held that raising pigeons were pigeons within the meaning of the Waste Disposal Ordinance, and those persons who kept more than 20 raising pigeons in the specified urban areas were liable to prosecution under Section 15. On appeal, the Court of Appeal found it unnecessary to refer to the legislative material for all the Public Health Animals and Birds Ordinance, which was in a different context and of little assistance to the interpretation of the Waste Disposal Ordinance. The association was represented by defense counsel, Mr. Hui Ka Ho, who argued that pigeons were not poultry as a matter of ordinary English language, citing in support the meaning of poultry in the Oxford English Dictionary. Poultry, it was argued, referred to table birds. The court had no difficulty in rejecting this argument, noting the extent that pigeons were consumed on the table in Hong Kong. Mr. Justice Nazareth held that pigeons means pigeons. It was a plain and ordinary English word which must be given its plain and natural meaning. There was no ambiguity or obscurity in the statutory definition. The term pigeons must be intended to cover all kinds of pigeons, be they table birds, fancy birds, show birds, or racing pigeons. The purpose of the ordinance was to address the primary mischief of pollution caused by the waste of livestock, be they pigs or poultry or pigeons. Mr. Justice Liu added that the purpose for which the pigeons were kept was simply irrelevant. In contrast, Mr. Justice Bokhari expressed his sympathy with the association, but pointed out that the weight of the word pigeon in the statutory definition of poultry was too heavy for the association to overcome. Statutory interpretation is rarely a mechanical process. More often than not, there is a choice of range of possible meanings, and the courts are guided not only by the language of the statute, but also its purpose and context, and not surprisingly, their own sense of justice and fairness. The decision of Mr. Justice Sears was eminently sensible, with a nice human touch. The judgment of the Court of Appeal was impeccable, though it may convey a rather stern and literal-minded impression. Lawyers from both sides approached the case from different perspectives, and possibly with some ingenuity in this case. Those who have read the judgments might be forgiven for expressing sympathy with the cry in Shakespeare's Henry VI, "The first thing we do, let's kill all the lawyers."